Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. You know, in the Stefan Stearns case, perhaps we, being from law enforcement, made an assumption, and maybe our assumption can be proven incorrect, but I still think we are right. And our assumption is that when Detective Myra Tagler was questioning Stefan Stearns, a non-custodial interview, which means Stefan Stearns was not under arrest. He was free to leave. So it was a non-custodial interview. And when she asked him, and this was all recorded, is it okay if I look into your phone? And he responded, yes, yeah, you can look into it. And that is done across police departments all across this nation, of voluntarily allowing the police to do something. And when you respond, and I assume that Myra Tagler also got written consent from him to go into his cell phone. And once they go into his cell phone, they find all of these horrific images that now, after they have found these images, absolutely, Stefan Stearns is under arrest and is not free to leave. That's where, when we talk about crossing the Rubicon of probable cause, that was it. He crossed into probable cause and he was under arrested. And we use that little sort of formula: in custody plus interrogation equals Miranda. And at that point, Miranda would have been required because he was under arrest. But before that, he was not in custody. He even said to her, oh, do you mind if I move my car? And she said, no, you don't have to move your car right now. Just leave it where it is because the detectives just want to take a look. So if he even thought that he was free to go outside, which he obviously did because he volunteered to move his car. So we're going to get into this a little deeper, a lot deeper, actually, because if this judge throws out this evidence, and we'll hear the term fruits of the poisonous tree, and it's from the law, fruits of the poisonous tree doctrine. And that simply means evidence that is obtained illegally will be thrown out and suppressed and will not be allowed to be used. So if the judge rules that this phone evidence, this digital evidence, these pictures, these videos are fruits of the poisonous tree, this whole first case and possibly the murder case could be imperiled, because this evidence gives them more time to investigate the murder. I believe they would have arrested him for the murder anyway, but it gave them time and a stronger case to keep him inside while they investigated the murder. But this is, I really believe this judge is trying to be fair, but I think if he makes this decision to suppress this, he will absolutely, and it's not his concern that he's destroying the case. His concern is to abide by the law. But I think that the police acted within the scope of the law, and this could be quite disturbing if this in fact occurs. So folks, hold on to your hats, hold on to your loved ones, hold on to your cup of coffee, hold on to your thoughts. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone. There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
And now a word from our sponsor. BetOnline is the world's most trusted betting platform and your number one source for all your sports betting action. Baseball season is in full swing and we're into the home stretch for NBA and NHL playoffs. And there's more ways to stay in on the action with the latest odds, news, and scores, even live in-game betting while the games are being played. With the largest odds, a selection of odds on everything from Major League Baseball, National Hockey League, and UFC, BetOnline remains the number one online source for all your sports wagering info. In between games, head over to the BetOnline Casino with all the top Vegas-style games, including poker and live casino. BetOnline, the game starts here. Joining me today, you'll be thrilled, is retired NYPD Sergeant, professor at Albertus Magnus College in Connecticut, an attorney. It's great to have an attorney on, especially with these legal issues. Welcome to the show, Professor Mike Geary. Welcome, Mike.
Bill, thank you for having me on. Good to see you.
You know, Mike, I just couldn't even imagine that the judge would rule or will rule to throw this evidence out. First, it's cataclysmic. If that in fact occurs, first of all, I think he's wrong. I don't think he's wrong to look into it, to deeply, deeply research it. I think he's correct to do that. But I think if he comes up with the opinion that it's the fruits of the poisonous tree, it's cataclysmic to the prosecution.
Bill, if the judge does decide, I agree, if the judge does decide that the police violated his Fourth Amendment rights by not getting actual real consent, then anything found on that phone would be fruits of the poison tree. And so therefore, throwing it out would be really difficult for now the prosecution, because that is the vast majority of that evidence, the vast majority of evidence that will be used against him in that case. The only way the prosecution would be able to survive that sort of ruling by the judge to throw out that evidence would be if they had any other evidence gathered against Stefan Stearns from different and independent sources. If they've got that, then the case would still be on. But this would be a very tragic and cataclysmic event for the prosecution in this case.
You know, Mike, I think one ace in the hole that if the judge does throw this out, perhaps Jennifer Soto would need to testify. But her testifying, I don't know, they would probably have to give her immunity, because we've all been baffled as to the point, well, why hasn't she been charged? So that could be the ace in the hole for the prosecution, but I just think it will be cataclysmic if this judge throws this evidence out.
You're right. The moment you mentioned Jen Soto, the first word that popped in my head is immunity. That is what you're going to have to give. You got it right. They would have to give her, use immunity, or blanket immunity, I think is a proper term, and say, look, you will get immunity from everything you say in this case. And if she didn't do it, and she would then be, could be charged later. But if she agrees to testify, then with her attorney's going to be in court, and her attorney and the prosecution will be going over each and every question that is asked of her. They will completely compromise any further case against her in the future. And you and I have seen, and many people have seen, some of her own exchanges with detectives, and they are really troubling. But in order to get Stefan Stearns, and prosecute him, you may actually have to just say, shake your head as a prosecutor, but say, we got to bring her on. We got to give her immunity. We're going to compromise future cases, a case against her, but we have to win this case against Stefan.
Absolutely. This is from Fox 35 in Orlando.
Stefan Stearns' trial that we know has been pushed back as a judge weighs a decision on the evidence. We talked about this yesterday because of that suppression hearing where the judge is going to be considering whether or not to allow evidence specifically concerning from the cell phone of Stefan Stearns. This is in the sexual battery case that was originally slated to go to trial May 5th, that is now scheduled to go to trial in July. So a lot of interesting things in court yesterday, and as this case kind of moves forward. Joining us live now via Zoom to talk about this is Lauren Cadillac, who is an attorney, the owner of Cadillac Law in Dallas, and also someone that we've spoken to before, specifically when we were talking a lot about Sarah Boone. And so, Lauren, we appreciate you joining us from Dallas this morning.
Thanks, Garrett. It's great to be here, and I appreciate it. Good morning.
Good morning to you. I know this is a case that you are also following.
I'm not going to have her because we have Mike here to talk about this, but I just wanted to put up some of the
new. Just kind of give me your
the new dates that are going to be there. You have on the screen. June 30th, the judge will be ruling on the evidence. July 2nd, there'll be a pre-trial hearing. July 14th, the jury trial begins. September 22nd, the capital murder case begins. So all of these things are coming up, but this is. Look at all of the time that the judge gave himself. So he obviously, this is a huge legal issue, and he may even ask for the assistance of other legal scholars because this is such an important ruling. Your thoughts, Mike?
Bill, I think, we talk about consent, and waiver of the Fourth Amendment rights, that sort of thing, consenting to talk to the police. The only time the police have a duty to inform a criminal suspect of their rights, it would be under the Fifth and Sixth Amendment in a Miranda kind of situation where that person's in custodial interrogation. I think the prosecutor did a great job in her arguments to the judge by saying, look, none of the police officers had their firearms out. It was not a custodial or coercive environment. He was free to walk around, talk to the police. In fact, at one point, she said that the police were actually talking to Stefan Stearns, like shoulder to shoulder, outdoors, talking about, where poor Maddie was last seen and things like that, that he was free to go. He actually asked to move his car, and he said, and they're like, no, don't worry about that. And that when he gave Detective Tagler the phone after she asked for it, he didn't expressly state, you can only look at my pictures, you can only look at cell phone record, the call record. I'm limiting you to text messaging, nothing like that. And I think the prosecutor brought that out really well. And she told the judge, reminded the judge that looking at the issue of consent, you look at objective reasonableness. Remember, the police have to act reasonably, and were they acting reasonably considering the issues they were facing? You have a poor girl has been missing for 24 hours, and she's out there somewhere. Speed is of the essence. They asked for that phone. In fact, he even told them how to unlock the phone because they didn't know how to unlock the phone with whatever code number he had. I think the prosecutor did a great job.
Absolutely. So on February 26th and 27th, while the police were still searching for Madeline Soto, they interviewed Stefan Stearns multiple times as part of their investigation. It was during one of those interviews that a detective began looking through Stearns' phone and allegedly discovered photographs showing Soto being sexually abused. Now, she looked through the phone after asking permission. Stearns' defense said that the detectives never obtained a warrant to search the phone and argued at Wednesday's hearing that all evidence found in the phone should be tossed from his upcoming trial on SA charges. Stearns testified at the hearing saying that he believed detectives were just going to check my Google Maps. That was it. That was all I agreed to. He never said anything like that. Prosecutors said that Stearns gave the detectives verbal consent multiple times at the scene and noted that because they were standing next to each other, Stearns could see what the detectives were looking at on the phone. But Stearns' defense said that's not enough. And while acknowledging that legally Stearns was not in custody and was free to leave, suggested a reasonable person would not have known that. While a warrant would normally be required to search private property, prosecutors say in this case, probable cause combined with the exigent circumstances of Stearns' factory resetting the device in an alleged attempt to delete evidence was sufficient for officers to take the phone. Stearns' defense argued that once the factory reset was done, there was no exigency because he had already acted. Judge Keith Karsten said he would weigh the arguments and issue a ruling at a later date. So the legal issue, Mike, is, look, I'll say right here, this is police, it's true crime from a police perspective, but I think the police did everything right in obtaining his consent. And again, he was not in custody, which is one of the most important things.
Bill, you're absolutely right. And I agree with you. We look at things from a police perspective because we've done these sorts of things, asking people these questions in the past. And in this case, Stearns gave consent. Yes, you can, and the defense has to say, yes, he agreed to hand over the phone. But in his mind, he was thinking in his own head, they're only going to look at Google Maps. Well, the problem for him is the judge has to make his decision on objective indications of that consent. And the objective indications were that he never mentioned out loud, oh, you can only look at Google Maps, or something else. He never put any limits on it. He never directed the search. He never limited the search in any way verbally. So what was in his head doesn't matter because we don't have any objective evidence of what he really was thinking that night. What we do have objectively is the recording of Detective Tagler, who did a great job in this case, asking him, maybe look at your phone? Could you open it up for me? And he was responding positively. So I think the judge will ultimately agree with that Detective Tagler acted reasonably under the exigent circumstances. But I think also, as you pointed out, this case and the other case are tied in together. And this ruling is a huge ruling, and he wants to get it completely 100% right. I don't blame him. I think the judge is doing a great job.
Absolutely. This is Detective Myra Tagler testifying yesterday.
You're going in and out of St. Cloud.
Yes.
What times was it traveling towards or into St. Cloud?
It says eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Stearns in this case?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stefan Stearns.
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Miss Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stefan.
Is there law enforcement conversing with either Jennifer Soto or Stefan Stearns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stefan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stefan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes, Detective Hunt told me that Madeline and Stefan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stefan Stearns?
Yes.
How did you know who was Stefan Stearns and how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Stearns audio recorded?
Yes.
As a detective, What is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Stearns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Stearns with you and Detective Acosta?
No.
Where is Mr. Stearns when you approach him?
We're all standing behind his vehicle,
When you say his vehicle, who are you talking about?
the Lincoln.
So the defendant's Lincoln.
Yes,
And at this point in time, is the defendant handcuffed?
he's not.
Is the defendant free to leave?
Yes,
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
he was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Stearns' vehicle, but can you explain to the court where everybody is positioned?
Yes, I was standing on the left side of the trunk. Stefan Stearns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Stearns' path of travel impeded by either of you?
It was not.
Was Mr. Stearns free to leave?
Yes,
Did Mr. Stearns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
he did not.
Questioning continues inside an Osceola County courtroom.
So, obviously, Mike, the questioning is leading to he was not under arrest. He was free to leave. You weren't dressed in a uniform, so because a lot of defense attorneys would say he was intimidated because the police were up in his face. These uniformed Gestapo agents,
Right.
But detectives are dressed in what's called business attire. So Detective Myra Tagler made that perfectly clear, and on numerous, at least twice, the prosecutor said, and Stefan Stearns was not under arrest. He was free to leave. Is that correct? This is one of the biggest issues in this entire little conversation here, Mike.
Yeah, it's an excellent give and take with the prosecutor, because Detective Tagler is setting the foundation for saying, look, this was not a coercive environment. He was not surrounded by officers, glaring at him. There were officers in uniform. There were officers like she and her partner who were in business attire. She was standing right next to him by the car, shoulder to shoulder. They were having a conversation. At this point, Madeline was missing for almost 24 hours, like 16 hours at least, maybe 20 hours. And therefore, you have to find her. He is cooperating with them, talking to them openly. He didn't ask for an attorney. He didn't look around, and he wasn't intimidated. He didn't try to run away. They didn't have to catch him. He could walk around. He could talk to them, because at that point, they still are not exactly sure all of everything that's going on, but they're trying to get all the pieces together as fast as they possibly can. So this testimony is setting the foundation for what's going to come follow, which is, how did you ask for the phone? At any point, did you ask to see the phone? And then after the judge already knows the actual physical layout and how the conversation went, you get to the consent issue. It doesn't look like they're allowing the judge to see that. It doesn't look like there was any coercion whatsoever, that consent was
Mike,
all part of that transaction.
Could I just interrupt you for one second? There's an acronym I always remember, and it's called VIK, V-I-K.
Mm-hmm.
And the permission must be given voluntarily, intelligently and knowingly. And the reason also the prosecutor was asking Detective Tagler, was he at all confused? Did he seem at all like he didn't want to communicate? She was setting the ground to establish Vic voluntarily, intelligently, and knowingly he gave his permission. And I think that was rather clear. And I'm sorry to interrupt you.
Oh,
but
no,
I
that's
know
right.
we spoke about that before. And that is important also for the judge to say, well, yeah, when she asks him, can I look through your phone? And I also want to just back up for 1 second. Exigency. Don't forget, when all this was going on, Madeline Soto's body was not recovered. They didn't even know she was in fact unalived at that point. So exigency. There was exigency to finding her, to getting the evidence quickly, so that perhaps a warrant would have taken too long because she could have still been alive. That's what was in the mind of Detective Tagler. Mike.
That's right. And her conversation, as she said to the judge, he was clear-headed. He was sober. He was clear-headed. He didn't seem like he was under any sort of medication. He wasn't sleepy, intoxicated, high on narcotics. He was clear-headed and having a normal conversation with them. His affect seemed to be very emotionless, but he was very clear-headed and answered all the questions willingly. He was not showing any signs of reluctance. So therefore, he is Vic. He voluntarily handed over the phone. They didn't have to grab it out of his pocket while, he didn't drop it while he was running away. He voluntarily handed it over. He knew what they were asking. He understood completely with clear head that he was they were asking to see the contents of his phone and to take a look at his phone. So therefore, it's knowingly, voluntarily, and intelligently given. So I think the judge is just being really, really careful. I think the prosecutor is being really careful. I mean, you could tell that is a very long foundational question, question answer period. But I think they did a great job.
100%. I want to play a little bit of this from, we all remember this interview.
You're a very intelligent person. And I don't want you to discredit yourself by saying you don't know about all the pictures that are on your phone. I want to let you know you're not free to leave. You're being detained. Okay.
So at this point, he's informed of the fact that he is in fact under arrest and he is not free to leave. And I'll keep playing this. We all see what he does, of course.
Do you want to know what you're being detained for? Capital sexual battery and possession of child pornography.
Defendant Stefan.
So that is clear. Once he knew he was under arrest, what did he do? He invoked counsel. So at no time did he believe he was under arrest with Detective Myra Tagler. He would, hey, am I under arrest? No, you're not. You're free to go. So at no time. So that is one of the things that the judge will make his decision upon. In custody plus interrogation equals Miranda. And you see, when he was told that he was now in custody, he lawyered right up. Mike.
Bill, it's excellent because it shows how quickly he realized what was going on. He knew the jig was up. When he's talking to Tagler several days earlier outside, and they're standing like right next to each other, leaning against the car, having a conversation, he was really sure that he was completely in the clear, and all he had to do was keep talking and being very vague, and he'd probably get over on everybody because he knew in the back of his mind that he had destroyed all the evidence on that phone. So when he hands it over, he immediately says, "Oh, by the way, I unfortunately, I don't know how that happened. I factory reset my phone, but here you go anyway." He was perfectly fine to hand that over. He didn't talk about his rights. He didn't ask for counsel. He didn't tell anybody he didn't want to talk to them any longer. He talked as much as he wanted to, but in that position right there, as you see the detective talking to him, and now he realizes, oh my goodness, the jig is up. He immediately invoked counsel. Two very, very different situations and with different outcomes. So I think the detectives respected his constitutional rights in scrupulously observed his constitutional rights in both instances.
You know, this judge now has given himself over 2 months to research this. And so let's hope that he makes the correct decision. You know, folks, we just wanted to come on and give a quick update on this case, but this case needs much more. Perhaps this evening, Mike and I may do a follow-up on this, but I want to thank everyone for tuning in. Mike, your final thoughts.
Final thoughts, just to let everybody know that the police, in our estimation, the police did everything they could to and scrupulously observed, Stefan Stern's constitutional rights, and that they were not using any underhand or trickery or anything like that. They followed the law scrupulously, and therefore I believe that the judge will rule that the consent was given knowingly, voluntarily, and intelligently given, and all of that evidence will come in at trial against him.
Let's hope so. Folks, thank you so much for tuning in. I'm Bill Cannon from Police Off the Cuff. Have a great day, everyone, and God bless.
One episode just ain't enough.